it a short note on the right to move freely throughout the territory of India. What restrictions can be imposed on the said right? Ans. Article 19, 1d guarantees to all citizens of India the right to move freely throughout the territory of India. This right is, however, subject to reasonable restrictions mentioned in Clause 5, Article 19I, in the interest of general public or for the protection of the interests of any scheduled tribe. Article 19, 1d of the Constitution provides the citizens a right to go wherever they like in Indian territory without any kind of restriction whatsoever. They can move from one state to other and also from one place to another place within any state of India. This freedom cannot be curtailed by any law except within the limits of Article 19, 5. In this way, Constitution stresses that the entire country is one unit so far the citizens are concerned. The object is to create the sense of nationality in the minds of the citizens. Grounds of restrictions. The state under Clause 5 of Article 19 may impose reasonable restrictions on the freedom of movement on two grounds. 1. In the interest of general public. 2. For the protection of interest of any scheduled tribe. In N.B. Khare v. State of Delhi, AIR 1950 SC-11, the petitioner was served with an order of externment to remove himself from Delhi for a period of 3 months. The petitioner contended that the order imposed unreasonable restrictions on his right guaranteed under Article 19, 1d because 1. The issue of the order depended on the subjective consideration of the executive, and 2. The act under which the order was made did not prescribe any time beyond which the order could not continue. Accordingly, it was held by the Supreme Court that the mere fact that the order depended on the subjective considerations of the executive did not make the restriction unreasonable because the desirability of passing such an order in emergency has to be left to an officer. Secondly, as the act itself was of a limited duration, there was no possibility of an order being made for indefinite period. In state of HPV, Umad Ram Sharma, AIR 1986 SC 847, it was observed that every person is entitled to life as enjoined in Article 21 of the Constitution, and in the facts of this case read in conjunction with Article 19, 1d, to move freely throughout the territory of India, and he has also the right under Article 21 to his life, and that right Article 21 embraces not only physical existence of life, but the quality of life. Accordingly, there should be road for communication in reasonable conditions in view of our constitutional imperatives, and denial of that right would be denial of the life as understood in its richness and fullness by the ambit of the Constitution. To residents of the hilly areas so far as feasible and possible, society has constitutional obligation to provide road for communications. In state of UP v. Kaushalya, AIR 1964 SC 416, it was held that the right of movements of prostitutes may be restricted on the grounds of public health and in the interest of public morals. In Raja Sukhandas v. State of UP, AIR 1974 All 498, the validity of Section 3 of the UP Control of Gundas Act 1970 was challenged. The Supreme Court, while upholding the validity of the said section of UP Gundas Act, observed that the purpose of the act was to control nefarious activities of the unsocial elements, and the act defined the word gundas, which showed that it covered only such persons who carried on activities which were against the interest of the general public and therefore be prohibited under Clause 5 of Article 19. Restrictions on the right of movement for the protection of the interest of the scheduled tribe is based on the fear that uncontrolled mixing of the tribe with the people of other areas might produce undesirable effect upon the tribal people.